Okay, we're going to get rolling again. It's my pleasure to introduce Michael Milov-Cordoba. He is counsel for Brennan Center's Judiciary program, where he works to ensure that courts uphold democratic values and the rule of law. He's the co-author of multiple nationally recognized reports, including Supreme Court Term Limits, A Path to a More Accountable High Court. His scholarship on courts and democracy have been published in the New York University Law Review, Hofstra Law Review, the University of Pennsylvania Journal of Law, and Social Change. His comments and work have been featured in media outlets such as the New York Times, the Los Angeles Times, and he regularly contributes to the State Court Report, a Brennan Center publication focused on state courts and state constitutional law. Prior to joining Brennan Center, he served as a law clerk to Judge Alvin Thompson of the U.S. District Court of the District of Connecticut. He holds a bachelor's degree, summa cum laude, in law, jurisprudence, and social thought from Amherst College, and a master's degree in political science from Columbia University. He received his law degree from NYU School of Law. This is his first trip to Montana. So we welcome him, and I have suggested he hasn't seen enough of it, and so please be nice, because we want him to return. Please welcome him.
All right. Thanks so much for the warm welcome. I'm really excited to be here. I've never been to Montana, and I'm really honored to have been invited by Betsy and the Friends of the Third Branch to speak alongside so many great public servants. So my name is Mike Milov-Cordoba. As Tasha mentioned, I'm an attorney at the Brennan Center for Justice based in New York. I'm going to be talking today broadly about the national picture when it comes to state courts. We've heard a lot about what's going on in Montana. I'm going to provide some national context. And in particular, I'm going to talk about, why it is that we're seeing, or at least offer some theories as to why it is we're seeing broad efforts to like political pressure to undermine the independence of state judiciaries across the country. I'm going to walk through the various forms of political pressure that judges are under, and that'll be the bulk of my presentation. And then I'm going to elevate some notable examples of state judiciaries alongside attorneys pushing back against some of these efforts. For folks who are unfamiliar with the Brennan Center, we are a think tank affiliated with NYU School of Law, founded by Justice Brennan and some of his clerks. We are a nonpartisan law and policy institute that seeks to improve our systems of democracy and justice. We work to uphold our political institutions and laws accountable to the twin ideals, American ideals of democracy and equal justice for all. I'm on the judiciary, and in the judiciary program, and that's where all the courts nerds work at the Brennan Center. So you all are spending a beautiful afternoon inside a law school library talking about state courts, so I don't need to dwell too much on this slide, but the story of the politicization of state courts begins with the fact that they're very important institutions. 95% of all cases filed in state court. I've seen some numbers recently suggesting that it's maybe closer to 97. So the overwhelming majority of litigation happens in state courts. State Supreme Courts are typically the final word on state law. And state courts, of course, general jurisdiction, hear all kinds of cases from property rights, economic liberties, land use, gerrymandering, abortion rights, criminal law and procedure, environmental law. All the issues end up in front of state courts. Now, that doesn't explain why in recent years we've seen an uptick in various forms of political pressure being applied to state courts. And so I want to offer a couple reasons why that may be the case. Some of them have nothing to do with courts at all. The country is struggling with an intense period of political polarization. There's a broad mistrust of institutions, from Congress to the US Supreme Court to legislatures, all the way down to the local level. That's making it harder for folks to have faith in our institutions. But there's also some court-related reasons why we're seeing a kind of intense interest among state political branches when it comes to state courts. And from our perspective at the Brennan Center, it has to do, at least in part, with developments from the US Supreme Court. So for the past, let's say, 50 or so years, the US Supreme Court has, broadly speaking, been receding from the national protection of certain rights. Things like, not only like abortion rights and partisan gerrymandering recently, but also things like education funding, takings clause claims, things like that. That has had the effect of moving contestation over those claims to state courts. State courts are now deciding more and more cases under their state constitution. They're being asked to decide more and more of those disputes under their state constitutions. That in turn has drawn the attention of state political branches, outside interest groups, advocacy groups who are trying to exert more pressure on state judiciaries. And this takes multiple forms. One is legislation. So political branches are pressuring state judiciaries with laws. Laws attacking judicial powers and independence, which I'll spend the bulk of my presentation talking about. We're also seeing judges threatened with impeachment proceedings, not for having committed or alleged to have committed high crimes and misdemeanors, but to retaliate against judges for specific rulings. We've also seen court budgets used coercively to try to pressure judges to issue specific decisions on certain types of cases, and then some alarming defiance of court orders or getting quite close to the line as far as defiance of court orders. Outside of the state political branches, there's also a broader environment that's contributing to the undermining of judicial independence in our state judiciaries. There is unprecedented amounts of spending on judicial elections. You all in Montana have been at the center of that. That is not good for our system of democracy. It is hard to have faith in the impartiality of judges when we're spending more money on state Supreme Court elections than we are on electing US senators. And there's also, most alarmingly of all, serious judicial security concerns. Threats against judges, against their families, against court officers are on the rise at the federal level, they're on the rise at the state level, and that sort of very straightforwardly is a serious matter when it comes to judicial independence. So I'm going to walk here through just a couple examples of this dynamic, right? The way in which the Supreme Court's withdrawal of national protection of certain rights has kicked issues to the states, that has in turn attracted the attention of various interest groups and the state political branches. So on public education, the Supreme Court declared decades ago that education is not a fundamental right. With respect to takings, the Supreme Court declared that private economic development can satisfy the public use requirement in Kilo. With respect to reproductive rights, Dobbs abolished the federal constitutional right to abortion. On gerrymandering, in Rucho v. Common Cause, the U.S. Supreme Court declared that partisan gerrymandering claims would be non-justiciable, kicking that issue to state courts. And then on environmental rights, this is a little bit of a different sort of posture, but the Supreme Court has imposed limits on the administrative state, at least in certain cases, to address efforts to address climate change. And state courts are filling the vacuum. They're now deciding greater numbers of cases in important areas of the law. There was a wave of public education, state constitutional public education funding cases shortly after the Supreme Court declared that education was not a fundamental right under the federal constitution. Many of those cases are still ongoing. There are new issues emerging in the education litigation landscape, cases on not just funding, but vouchers and charter schools. On takings, many state courts responded to the Supreme Court's ruling by strengthening state constitutional limits on government power to take land for public use. There have been dozens of court rulings on reproductive rights since Dobbs, many state constitutional amendments post-Dobbs. There's now litigation under those amendments, so this will continue for the foreseeable future. On voting rights, partisan gerrymandering claims are being litigated across the country. Some state courts are declaring them justiciable under their state constitutions, some courts are not. And then on environmental rights, there are landmark state constitutional climate lawsuits, including here in Montana. So the basic dynamic I'd like you all to take away is right here on this slide. With state courts now deciding more major cases previously decided by federal courts, right? That withdrawal of national protection, a kind of like elevation of federalism in our country, not an inherently bad thing. But the consequence of that is that state political branches are trying to prevent state judges from checking unlawful exercises of legislative power and to stop state judiciaries from acting as an independent branch of government. So at the Brennan Center, we publish an annual report called Legislative Assaults on the Courts, where we track efforts by state legislatures to undermine the independence of courts, to diminish their role or powers, to politicize judicial selection, and just make it harder for them to do their jobs. We compile those findings into annual reports that you can find on our website, and I have some of the top lines from those reports here. And as you can see, there are, between 2020 and 2024, we have identified 442 bills that were introduced and 47 passed that in some way diminish the role, independence, or powers of the judiciary. We will be having our 2025 report come out at the end of this year or early 2026, so you'll be able to see what went on in 2025 when that comes out. Now, what are the types of legislative assaults? What are the types of legislation that we're seeing across the country? And you'll see here, as I talk through these, similar themes as some of the folks who spoke before me touched on. So to begin with, we've seen bills making partisan changes to judicial selection. These are things like adding more political appointees to politically independent judicial nominating commissions, trying to make judicial elections more partisan in some way. The second category are judge shopping cases. So these are efforts by state political branches to change the judges or courts that hear certain high-profile cases, most commonly constitutional cases against the state. We're also seeing efforts to gerrymander or eliminate judicial districts in states that elect judges in order to retaliate against judges for issuing particular decisions that the state political branches disagreed with. There's also efforts to politicize judicial discipline and ethics, things like adding more political appointees to politically independent ethics bodies. And then finally, there are straightforward bills that are limiting courts' powers to enforce their rulings, things like jurisdiction stripping or limitations on the remedies that courts can provide in certain types of cases. I'll be spending some time talking about judicial selection, and various partisan efforts to change judicial selection. But to level set, I thought I'd talk just briefly about the various ways that states select judges. And there's really a handful, as you can see on this slide here. The most common way, two most common ways are nonpartisan elections, it's what you all have here in Montana, and merit selection, sometimes called the Missouri Plan. For folks who are unfamiliar, merit selection is the process by which judicial vacancies are filled with a judicial nominating commission. So applicants apply to fill vacancies. That commission vets applicants and makes a recommendation or provide a short list to an appointing entity, typically the governor, who selects from that list. The judge is appointed, and then the judge stands for regular retention elections thereafter. 10 states use gubernatorial appointment. Those are mostly concentrated in the Northeast. You can see from this map. 7 states use partisan elections. That number in 2016 was 5. In 2016, North Carolina implemented partisan elections. In 2022, Ohio, implemented partisan judicial elections. So that number is now 7. And then a few states use hybrid systems or legislative appointment. So I'm now going to walk through the various categories of legislative assault and offer some examples of what we've seen across the country over the past several years. So in recent years, lawmakers have made partisan changes to how judges are selected, and we've seen a correlation between state interest in this with recent abortion decisions. Utah, Oklahoma, and Kansas are the examples that I provided here. So Utah, Oklahoma, and Kansas use merit selection to select their judges. In 2023, Utah passed a law removing partisan balance requirements on their commission, right? There used to have to be a certain number of Democrats and Republicans on the commission, and gave the governor full control over appointees, so the state bar had less influence over the judicial nominating commissions. This followed a high-profile ruling on abortion by the Utah judiciary. In 2024, a very similar story. Oklahoma considered and one chamber passed a constitutional amendment to abolish merit selection in the state. That too followed a high-profile abortion decision. The Oklahoma Supreme Court recognized a narrow state constitutional right to abortion. And then in 2025, just this year, the Kansas legislature referred a ballot measure, which will appear in the August 2026 primary ballot to abolish merit selection. There too, the Kansas Supreme Court just prior issued a decision reaffirming the state constitutional right to abortion. So why does this matter, right? Why are legislators interested in changing judicial selection? Well, it's because these changes, I don't know what that is. It's because these changes impact case outcomes. Different selection systems prioritize different values. There's usually a trade-off between democratic accountability and political independence. But the reality is that we've seen over the past several years that major changes to how judges are selected have led to differences in case outcomes. So I'll give 2 quick examples here. North Carolina in 2016 implemented partisan judicial elections for its state Supreme Court justices. Shortly thereafter, after a couple election cycles, the North Carolina Supreme Court reversed precedent on voter ID and partisan gerrymandering. One of those cases was just a couple months after a flip in the court. Iowa is a similar story. In 2019, Iowa, a state that uses merit selection, enacted a law giving the governor a majority of appointments on the state's judicial nominating commission. That commission was previously equally divided between the governor and state bar appointees, with the longest serving justice, who's not the chief justice, serving as the chair. With the governor having a majority, the types of judges that ended up making it through the commission changed. And after a couple changes on the court, Iowa ended up reversing its precedent on abortion, as well as most recently some precedent on state damages, the availability of damages under state constitutions. The second category of what we call legislative assaults are judge shopping bills. In recent years, lawmakers have engaged in judge shopping by routing or trying to route constitutional challenges to state law to or away from certain judges or certain districts. And I've got two examples of that here. Between 2019 and this year, Kentucky has enacted multiple laws routing constitutional challenges away from judges in the state's capital, following litigation in the capital, striking down high-profile legislation. I'll talk more about the fallout from that in later slides, but as a second example, North Carolina, similar effect, slightly different mechanism. So between 2023 and 2024, North Carolina added 12 special Superior Court judgeships. I had to look up what special was when I was reading those bills. Essentially temporary judgeships to be appointed by the legislature for 8-year terms to hear constitutional challenges and redistricting cases. In the 20 or so years prior, the state appointed or created only 17 special Superior Court judgeships. They served shorter terms, and the governor appointed them. And those judges could not sit on panel in constitutional challenges or redistricting cases. The third category is gerrymandering or eliminating judicial districts. In recent years, lawmakers have retaliated against judges for striking down legislation by eliminating or trying to gerrymander their districts. Between 2020 and 2021, the Pennsylvania legislature nearly succeeded in referring a ballot measure that would have required appellate judges to run in districts. Front and center opposes districted judicial elections. This followed a decision by the Pennsylvania Supreme Court striking down a partisan gerrymander. 2024, North Carolina eliminated the districts of 2 judges who issued major decisions against the legislature in democracy cases. This is sometimes called double bunking, right? You eliminate the districts and combine them into one, forcing the judges to run against each other. There are very few limits on legislative power over the drawing of judicial districts. So there's not much that can be done about this, but the reason these judges were targeted is because both had struck down legislation that displeased the state's political bodies. So Judge Burke struck down an effort to exert more legislative control over the state election board, and Judge Collins voided a constitutional amendment on voter ID and state income tax cap because the legislature that referred the ballot measures was racially gerrymandered. Now this matters because how we draw judicial districts changes court composition, and that in turn has effects on case outcomes. In 2021, Illinois redrew its state Supreme Court districts. It's one of the few states that elects its justices with districts. They redrew them after a Democrat lost the retention election. The new maps created 3 solidly Democratic districts and a 4th that has voted for Democrats in recent statewide elections. So it appears that the state Democrats in the state were concerned about losing control over the Supreme Court, and so they redrew the maps. And this is all to say that we've heard a lot about sort of Republican-led efforts to attack judicial independence, but this also occurs on the left. The 4th category are bills to politicize judicial discipline. In recent years, lawmakers have sought to increase their control over state judicial ethics bodies, largely to, well, I'm not going to impute intent to the legislators, but they've sought to increase the number of appointees on state ethics bodies. And one example of this is Arizona. So in 2024, the Arizona legislature referred a constitutional amendment to the ballot that would have politicized the state's Judicial Ethics Commission. How would it have done that? It would have added legislative seats to that body, and most alarmingly, it would have empowered individual legislators to require the commission to investigate an allegation of judicial misconduct. So it really would have empowered individual legislators to be a thorn in the side of particular judges who were issuing rulings that displeased that legislator. This was opposed by retired judges in the state, and thankfully widely rejected by voters in the 2024 election. And this matters because politicizing judicial discipline can threaten judicial independence. I'll offer a case study here from 2020 featuring the Wisconsin Justice Jill Karofsky. In 2020, the Wisconsin Supreme Court, like many states, heard a case over the 2020 election results. During oral argument, Justice Karofsky stated that efforts to disenfranchise voters in just 2 counties, the 2 most diverse counties in the state, smack of racism. In response to that and other things that occurred during the hearing, the Wisconsin Ethics Commission opened a 16-month investigation. Among the allegations were that she had used facial expressions that were improper, had spelled out the word application in a kind of demeaning way, and was reviewing notes. She was forced to hire a lawyer, pay out of pocket for this. And I have a quote from her up here. She wrote an article in Slate about this if you're curious about her experience being under investigation. She said, "My oath of office requires me to defend and protect the Constitution of the United States and the state of Wisconsin. My actions were not partisan. They were an attempt to protect our democracy and its democratic systems. I worry that unless I speak out, jurists around the country may be chilled from doing the same." And then the final category of legislation undermining the independence of state judiciaries are laws limiting judges' ability to enforce their court orders. In recent years, lawmakers have passed laws limiting judges' authority to hear or issue remedies in cases, particularly dealing with elections, abortions, guns, these like hot button cultural issues and social issues. To give some examples, between 2021 and 2022, a number of states, Georgia, Kansas, Kentucky, Oklahoma, and Texas, enacted bills limiting judges' authority to issue certain types of remedies in election law cases. Many of those involved judges' authority to extend polling hours. On abortion in 2022, Oklahoma stripped Oklahoma courts of jurisdiction over cases seeking to enjoin Oklahoma's newly enacted abortion restriction. A similar story in Ohio in 2023, Ohio voters enacted a state constitutional amendment, a right to abortion, and legislators shortly thereafter floated a bill that would have stripped Ohio courts of jurisdiction to hear cases under the newly enacted amendment. And then on guns in Wyoming, Wyoming enacted a law in 2024 curbing a judge's authority to enforce state judicial orders prohibiting firearm possession by individuals deemed a danger to themselves or their community, sometimes called red flag laws. So this is a preliminary analysis of what we've seen in 2025. As I said, our report is forthcoming at the end of the year or early 2026. But so far, we've seen at least 150 bills introduced attacking judicial independence. Same types of bills. Bills to abolish merit selection, bills to politicize judicial elections, judge shopping bills, creating new courts to hear constitutional cases, trying to give the legislative branches more influence over state ethics bodies, and bills to limit courts' powers to enforce their rulings. Now, so far I've been talking mostly about legislation, right? Bills that are doing things to the judiciary or changing the structure of the judiciary, but there are other threats that judges are experiencing. We've seen, unfortunately, a rise in what I would call improper impeachment threats. So threats lodged against judges not because they violated the law or committed high crimes or misdemeanors, but simply because they issued a ruling that the legislature or individual legislators did not like. And in particular, there seems to be some correlation between striking down gerrymandered maps and calls for the impeachment of the judges who were in those rulings. Other threats to judicial independence, targeting court budgets. So we've also seen in recent years state political branches, both legislators and governors, use their authority over the budget to try to pressure the judiciary to issue decisions in certain cases. So a good example is Alaska. Several years ago, the Alaska governor at the time withheld funds that had been allocated to the judiciary, specifically to retaliate against the judiciary for its abortion decisions. There was litigation over that withdrawal of funds. The governor vetoed the next year's budget line as well. The judges eventually got their money, but it illustrates the degree to which some of the political branches are motivated to go after courts for issuing particular rulings. Defiance of court orders. Unfortunately, we are seeing state political branches, if not outright defy court orders, at least slow walk obedience to court orders. And a good example of this is Ohio. So between 2021 and 2023, the Ohio Supreme Court declared on multiple accounts that Ohio's legislative maps violated Ohio's constitution as a partisan gerrymander. The state's redistricting commission slow walked compliance. They submitted maps that were not compliant. The court told them to go back and do it again multiple times. This essentially occurred up until the point where the swing vote on the Ohio Supreme Court was term limited. She reached her mandatory retirement age. There was a swing on the court, and the plaintiffs eventually withdrew their case. So there's also the money, other threats to judicial independence. So in addition to the state's political branches lodging these attacks on state courts, there's also tons of money being spent by outside interest groups. I have here, the Brennan Center every year tracks spending in judicial elections. I have some top lines from our reports on this slide, but really we're seeing record spending year after year after year. Between 2021 and 2020, there was over $100 million spent in state Supreme Court elections. Now, at that time, that was nearly twice the spending in any prior midterm election. In 2023, that record was smashed. Over 72 million was spent in just two races: Wisconsin Supreme Court race and a race for the Pennsylvania Supreme Court. That record was yet again smashed in 2025, where we're still sort of tallying the numbers, but it seems that by the end of when everything is tallied, folks will have spent over $100 million on a single seat on the Wisconsin Supreme Court. That's very alarming. As members of the public, as attorneys, it is not good that we are spending so much money to try to exert control over, try to win elections on our state Supreme Courts. And on top of that, the codes of conduct that govern judicial behavior are not keeping up with this, right? This spending increase has happened in just 5 years where we've blown through all the records and we are not keeping up with the disclosure requirements. We're not updating judicial codes of conduct to account for this new reality of huge spending in judicial elections. And then other threats to independence, unfortunately, we have to talk about judicial security. As I said at the top, in recent years, threats against judges have risen significantly. Since 2015, there's been a 400% increase in threats against federal judges, prosecutors, and court officials, according to data from the U.S. Marshals Service. Between 2021 and 2024, federal judicial security investigations doubled. And judges are feeling this. A survey put out by the National Judicial College survey found that 90% of judges that responded to that survey reported concerns about their safety. 71% of judges reported receiving an inappropriate communication related to their position, and 56% of judges, over half, reported being threatened at one point or another. Now, I've painted sort of a grim reality of where we are right now, but I want to elevate some positive examples of judges pushing back. Judges and attorneys working together to push back against some of these efforts to undermine their independence. So I want to talk a little bit about Utah. In 2025, Utah considered multiple bills that would have injected politics into judicial selection in the state. There was a bill to add legislative evaluations of judges seeking retention and to add that recommendation onto the retention ballot. There was a bill requiring the Chief Justice be reappointed by the governor and the Senate every 4 years, so requiring him or her to appear before the political branches regularly, and a bill to expand the court and add supermajority requirements for retention. Attorneys and judicial leaders pushed back. Legislative advocacy succeeded in Utah in defeating bills that threatened judicial independence. Utah's Chief Justice Durant said the retention bill would, quote, introduce partisan politics directly into the work of the judiciary and be, quote, detrimental to the public's trust in a fair and impartial judicial system. Utah Justice Peterson had similar remarks. She said the bills, quote, take aim at judicial independence and are, quote, obviously retribution for court decisions. Here in Montana, your Chief Justice spoke out commendably against the partisan judicial elections bill, and you'll be hearing from him just after my presentation. We've also seen not just legislative lobby succeed, but also litigation. In recent years, there's been an increase in constitutional litigation, challenging legislative efforts to undermine the powers and independence of state judges, and I'll talk about just two examples here. So I talked about Kentucky earlier, a state that had enacted multiple venue-changing laws to try to route constitutional cases away from judges in the state's capital. One of those laws was litigated. So in 2023, Kentucky enacted a judge shopping law. This particular law required clerks to transfer constitutional challenges to a randomly selected circuit when a notice of venue was filed. In Mississippi, a litigation was brought challenging a law that created new judgeships for Hinds County, where the capital is, to be appointed by the Chief Justice. Both laws were struck down. Kentucky Supreme Court held that the judge shopping law violates separation of powers provisions under Kentucky's Constitution, and the Mississippi Supreme Court held that the judgeship law violated the constitutional provision requiring that judges in the state be elected by the people. And I've got a quote here from the Kentucky Supreme Court ruling that I think is worth reading out loud. SB 126 dishonors the principle of separation of powers by granting unchecked power to a litigant to remove a judge from a case under the guise of a transfer, thereby circumventing our well-established judicial recusal process. Divesting the circuit court of its inherent jurisdiction and authority to decide when and if a case should be transferred to another venue, invading this court's rulemaking authority by permitting a notice of transfer pleading not authorized by Kentucky's rules of civil procedure, and exercising control over the court's clerks by directing them to take certain action for implementation of SB 126, which was the bill I'd issued in the litigation. And then there have also been public appeals that have had some success. So in nearby Idaho, Idaho judges spoke out in 2023 about threats being lodged against members of the judiciary. And in response to that, a bill was enacted exempting judges from certain public disclosure requirements of personal information, such as their address and phone number. And in 2025, we've seen some legislative lobbying among state judicial leaders to endorse federal legislation to establish a center to support greater security for judges. Right now, there's no national entity tracking threats to state judges across the board. It would be really great if we had one so we could support our judges in the important work that they do. So that's all I have for you today. These are some additional resources if you're curious. Our most recent legislative assaults reports available at that link. We have a report that comes out every other year called The Politics of Judicial Elections, where we lay out all the spending that occurred in state Supreme Court elections. The newest version of that will be coming out either later this year or early next year. And then we also have a newsletter all about state courts called State Court Report. It's a nonpartisan news source, resource, and commentary hub all about state constitutional development. So we have a case database where we curate the most significant cases dealing with state constitutional law, not just in the areas sort of Brennan Center is known for, like voting rights, but across the board: economic liberties, criminal justice, abortion, land use. And we also have a wide range of commentary. We have on-law scholars publishing pieces on the website, retired judges, current judges, advocates. So if you're interested in this stuff, it's a great resource. So I think with that, I'm happy to take questions.
Any questions?
Hi, Zach Bullheim from KPAX, local TV station. I'm curious to know where you think Montana sits in the mix of all the attacks on state courts.
Yeah, it's a great question. I would really defer to my earlier panelists who know more about Montana. I do have a slide later on here that maybe is responsive to that. But from my perspective, we're seeing a kind of broad attack on state judiciaries across the country, and Montana is very much in the mix. Certain things are happening in other states that are not happening in Montana, but there are some common themes, right? When you look at the types of legislative assaults that I've laid out here, partisan changes to judicial selection, judge shopping bills, elimination of judicial districts, politicizing ethics, attacking courts' remedial powers. There are examples from, if not this legislative session, but previous legislative sessions where Montana, the legislature has at least considered those bills, if not enacted them. So I think Montana is very much in the mix of what we're seeing nationally.
Other questions?
I don't think I need a microphone, but I'll ask a follow-up question of the same subject that I asked the last speaker. Can you tell us anything about coordination of these legislation, these batches of legislation that are popping up that look so much like each other across the country? Are there groups behind that, and if so, who are they?
Yeah, it's a great question. I don't have a good answer for you. I mean, from what we observe, legislators appear to read each other's bills across states. So I would echo the remarks that were made earlier to that regard. But I'm unaware of any sort of group organizing, telling legislators to write certain types of bills, to draft certain type of bills across the states. From what I gather, states learn from each other, and they draft bills that are similar to bills in other states.
Why do you think this is all happening now?
Well, I think it goes back to what I said earlier. I think that there's a kind of national, there are some intractable things happening in the country right now. deep polarization, mistrust of institutions, but there's also been activity of the US Supreme Court to withdraw national protection on really hot button issues, abortion, gerrymandering, things that legislators care a lot about, or at least some of their constituents or interest groups care a lot about. So there are policy fights happening over these issues, and judiciaries are caught up in those policy fights.
Thank you. Thanks for the work the Brennan Center does too.
Oh, you're welcome.
Sue Kirchmeyer from Missoula. You talked about the amount of money that's going into judicial elections. Can you say something about where the money is coming from? My understanding is that corporate treasuries are very active in the states. Guess I'll have to leave it at that. Thanks.
Okay. Yes, I would direct you to our report, Politics of Judicial Elections. My colleague Doug Keith is sort of the expert on this. In that report, there may be information about who's spending, but the reality is most of it is outside interest groups. Let's see if I have a slide on that. Yeah. So outside interest groups are spending more and more money on judicial elections. That's a problem in part because those ads tend to be more negative, which creates kind of an inflammatory environment around these races.
The second part of my question involved the Council on National Policy and their influence, say, on the Supreme Court and their activities really with money around the country.
I can't speak to that. I don't have an answer. I'm sorry.
Any other questions? I'll ask a question. What do you know about international attacks of the variety that we're seeing in the United States and at the local level? I attended a conference in Barcelona, and the suggestion from a couple of the presenters there was that other countries are facing similar hardships.
Yeah, that's Brennan Center doesn't really work on international issues, but there's been some interesting partnerships developing between some state-based groups and international groups where we've been exchanging notes on what we're seeing. And it is remarkable that we're seeing a lot of the similar attacks going after the way judges are selected, impeaching judges for improper reasons, trying to recreate judiciaries to sort of rubber stamp what the political branches do to prevent them from acting as an independent third branch. So I think, globally, folks seem to be less committed to the values of judicial independence and a real kind of robust third branch, which is unfortunate.
All right, well, let's please thank our speaker for coming to the